Back for part two now, after Steve's really useful chat this morning about R&D and the types of allowances that are available and the new patent box regime. Obviously the key is now how do we go and get a patent, and Noel is here to tell us all about how.
Thank you, Martin. Thank also to Steve again for what I found was an enlightening presentation this morning. As Martin's just indicated, I'll basically go through the essentials of the patenting procedure, because as Martin has also said, that is obviously a key requirement for being able to qualify for the patent box, and then take a look at some of the patent strategies generally, and also how they may be modified or affected by the patent box once it comes in. What can be patented? Basically, if you seek to answer that question by going to the Patents Act and looking for a definition of what is a patentable invention, you'd struggle. Basically, the law doesn't define what can be patented, but does it the alternative way around, which is to say what can't be patented. In other words, the law defines a number of exclusions from patentability. And in short, if you attempt to file a patent application, or you file a patent application in an attempt to get granted a patent for one of these excluded matters, then the Patent Office will jump up and object most strongly. Examples of exclusions that we typically run into are listed on the screen there. So we have computer programs, business methods, medical methods, so surgical methods, therapeutic, diagnostic, inventions that are considered to merely be presentations of information, and scientific theories. So Einstein and his glorious E=mc² wouldn't have been able to get a patent for that, but if he then reduced that to practice in some kind of drive system for a spacecraft or what have you, then there may be a patentable invention. What I would say on this particular point is that the law here in the UK and in Europe is generally rather restrictive. Basic requirements for patentability. First of all, you have to have something which is new, and it has to be new at the date that you file your patent application, and this is significant. And the law defines something as being new if it hasn't been made available to the public in any way prior to the date you file your application. And you can find that you have something which isn't new if it's been made the subject of an earlier publication, an earlier oral disclosure. So if I tell you now about one of our clients' latest inventions, that would count as a publication and could count against any later filed application. Sale of a product could disclose an invention as in the same way that public use could, if either of those put details of the invention into the public domain. What I also want to stress here is that the law doesn't distinguish between disclosures that you as inventors and potential patentees might make as opposed to those of third parties. So you are quite capable of affecting your own patent validity as well as affecting the validity of other people. So basically, key thing to remember is to make sure that if you're in any danger or any risk of making a public disclosure about an invention, to make sure that a patent application is on file at the Patent Office before you do that. Requirements for patentability, we have something which is new, so we're happy about that. The next thing that we need to do is establish that we have something which is inventive. There was a case a good few years ago where a company decided they wanted a patent on a blue squash ball. Up to that point, squash balls have been green or black. Filed a patent application. It was thrown out by the Patent Office as being wholly obvious. They actually took it to the High Court, and they persuaded the judge that no, this was not an obvious routine matter because the blue colour gave you a particular advantage. When you were playing squash, you could see the ball more easily, and it improved the game and it improved safety. And the judge, Justice Whitford, granted them their patent. But they really had to work hard to establish that they had something which was inventive. the patent timeline starts when you first file your patent application. Typically, for us here, that's going to be an application filed at the British Patent Office. And as I've said before, please make sure that that is before you publicly disclose details of your invention. Then we will have a period of 1 year within which we really don't need to do anything. And we can let the patent application sit there. Within that 12-month or 1 year period, we do have to make a decision on do we want protection overseas for the same invention, and if we do, provided we file those foreign applications within that 1 year period, we can actually benefit from our UK filing date. So what that means is I can today file for you a patent application at the British Patent Office at relatively modest cost. You can then tomorrow launch your fantastic new product, and provided that we get together before this time next year and decide on how to follow and file, you can file corresponding patent applications overseas and benefit from your filing date of today. That's a very powerful system, very effective, and it's used in the vast majority of all patent cases that are filed.